Let's talk about summary administration in the state of Florida. What is summary administration? Well, summary administration is an abbreviated version of probate. Well, what is probate, right? So probate is a legal process that helps do the distribution of assets and liabilities of a decedent's estate. Who or what determines if summary administration is an option for you? Typically, if a person has passed away with a will, testate, then the will may have directions as to how the administration must proceed. If a person does not have a will and they have passed away intestate, then the Florida statutes determines who can qualify for a summary administration. In order to qualify for a summary administration in the state of Florida, you must have the following criteria. You must have property that is less than $75,000, and that includes all of the assets of the estate. The decedent has to be deceased for more than 2 years, at the very minimum 2 years, and all creditors must be barred from recovery. Usually when we're using summary administration, it's because somebody passed away without a will, and we want to get the most abbreviated version of probate to get this thing in and out of the court system. Once we've determined that you qualify for a summary administration, your attorney, who is well seasoned in summary administration and probate law, will then determine what the next steps are. And typically you get a petition together, we get all the heirs to sign off on it, we submit all of our requests to the court, and the court makes a determination at that time. Once the court makes that determination, an order is entered and all of the assets are conveyed. Now, this may seem very simple and straightforward, and it should be, because that's the whole purpose of codifying the law, meaning we put a probate code together to make this as easy and streamlined as possible. But in probate, if it has taught me anything in the last 15 years, is that there's always a surprise when it comes to probate. So what's the takeaway? The takeaway is that Florida law allows you to have summary administration if you qualify. The second takeaway is make sure you have a seasoned probate attorney who can walk you through this process. And finally, always consult with a probate attorney before you start doing anything in the court. Because if you start and initiate an actual proceeding with the court, it may cost you a lot more for a lawyer to undo the damage that's already been done versus just hiring an attorney to handle your matter from the gate. So those are the takeaways. As always, I have to say, Florida makes law interesting, and apparently so do the people that live here in this state. So if you have someone that you know, or you are struggling with whether or not you need to have a probate done, again, contact a probate attorney who's seasoned and who knows what they're doing. And as always, if you like this content, don't forget to like and subscribe.